Hello everyone, I'm Aaratrika Bhaumik and I welcome you all to Courts This Week on LiveLaw, where we update you about the most recent legal developments from across the country. We will begin the episode with judgments from the Supreme Court and will then cover High Courts and other lower courts. The Supreme Court has passed an ad interim order to allow an unmarried woman to abort a pregnancy of 24 weeks arising out of a live-in relationship subject to a medical board constituted by AIIMS Delhi concluding that the fetus can be aborted without risk to the life of the woman. A bench led by Justice D.Y. Chandrachud observed that the Delhi High Court took an unduly restrictive view of the provisions of the medical termination of pregnancy rules while declining the woman's interim relief. Noting that after the 2021 amendment, the Medical Termination of Pregnancy Act uses the word partner instead of husband in the explanation to Section 3, the court said that this shows the legislative intent to cover an unmarried woman under the Act. The Supreme Court, in an application seeking compliance with its judgment regarding problems and miseries of migrant labourers, indicated that modalities have to be worked out by the central and state governments to ensure that migrant workers are provided ration at any cost. A bench comprising Justices M.R. Shah and B.V. Nagaratna said that they would pass orders with appropriate directions, which would include directions regarding provision of dry ration as well as directions to expedite the process of registration of all migrant workers on the eShram portal. Agreeing that the population figures have definitely gone up drastically in the past decade, Justice Shah also orally observed that issuing ration cards on the basis of the 2011 data might end up doing some injustice to the people who are in dire need of food supply. In the Gyanvapi mosque case, the Supreme Court has said that it will await the decision of the Varanasi District Court on the application filed by the Anjuman Intizamiya Masjid Committee, which manages the Gyanvapi mosque, questioning the maintainability of the suit filed by the Hindu plaintiffs. Accordingly, the bench adjourned the special leave petition filed by the Masjid Committee, challenging the civil court's orders for commission survey of the mosque to the first week of October. The court also refused to entertain two writ petitions which were filed seeking the right to worship the Shivling stated to be found inside the mosque during the survey and seeking its carbon dating and GPS survey. The Supreme Court has ordered the release of fact-checker Mohammad Zubair, the co-founder of Alt News, on interim bail in all UP police FIRs. A bench led by Justice D.Y. Chandrachud observed that existence of the power of arrest must be pursued sparingly by the police. The bench was also of the view that there is no justification to keep Zubair in continued custody any further and subject him to diverse proceedings when the crux of allegations arises from the tweets which form a part of the investigation by the Delhi police, in which case he has already been granted bail. The Supreme Court also refused to impose a bail condition that he should not tweet again. The Supreme Court has observed that statements made under Section 161 of the CRPC are relevant in considering the prima facie case against an accused in an application for grant of bail in a case of grave offence. The observation was made by a bench comprising Justices Indira Banerjee and V. Rama Subramaniam while setting aside an order of the Allahabad High Court that granted bail to a man accused of rape and murder of an 11-year-old girl. Taking a serious view of the trend of false implication of the relatives of the husband in matrimonial disputes, the Telangana High Court has recently observed that the false implication of the relatives of the husband in matrimonial disputes based on general and omnibus allegations, if left unchecked, would result in misuse of the process of law. With this, Justice A. Santosh Reddy ordered to quash further proceedings against the mother-in-law, brother-in-law and sister-in-law of a woman who had levelled allegations of harassing her for dowry. It is irony and tragedy of the Indian Republic and biggest scar on Indian democracy that criminals like Mukhtar Ansari are the lawmakers. The Allahabad High Court has observed this while it denied bail to the former UP MLA in a case wherein he has been accused of registering an ambulance on forged and fabricated documents. The bench of Justice Dinesh Kumar Singh further opined that since the ambulance was being allegedly used to carry Ansari's men armed with illegal and sophisticated weapons for his protection, therefore there was no ground to enlarge him on bail. The Jharkhand High Court has granted interim bail to News 11 Bharat journalist Arup Chatterjee while noting that he was arrested without following the proper procedure under Section 41A and the procedure pertaining to production of accused before magistrate under Sections 80 and 81 of the CRPC. Justice Sanjay Kumar Dwivedi also called for an affidavit from the state explaining the officer's actions and will then consider the question of arbitrary use of the police's power to arrest and the plausibility of initiating contempt proceedings. Chatterjee's bail plea was filed through Advocate Shawanaz Malik was dismissed by the trial court on the same day. The Gujarat High Court has held that a party can withdraw its consent for reference to arbitration under Section 89 of CPC anytime before the court has acted upon such a reference. The bench of Justice Umesh A. Trivedi was dealing with a special civil application under Article 227 against an order of the civil judge whereby the application jointly given by the parties to the proceedings to refer the dispute to the arbitrator under Section 89 Clause 2 Subclause A of the CPC came to be rejected on the original plaintiff who initially consented for the same withdrew the consent for sending it to the arbitrator. A Delhi court denied interim bail to Sharjeel Imam in an FIR relating to the alleged inflammatory speeches made by him in Aligarh Muslim University and Jamia area in Delhi against the Citizenship Amendment Act. The interim bail plea was moved by Imam in an FIR against him involving the offence of sedition under Section 124A of the IPC in view of the recent Apex Court order wherein the sedition law has been kept in abeyance till the Union government reconsiders the provision. Additional Sessions Judge Amitabh Rawat of the Karkaduma courts observed that there cannot be another bail application by Imam and another argument on the merits of the bail application when the court has already passed the order denying him regular bail as well as framing of charges against him on merits. Thank you. Keep watching Courts This Week on LiveLaw. If you like our content, do not forget to like and subscribe our YouTube channel.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.